On the morning of March 14, 2019, Dr. Sarah Chen checked the U.S. Patent Office database and found something that made her blood run cold. Her name was gone. The invention that would generate $80 million now listed only one inventor, her former business partner Marcus Webb. But what Marcus didn't know was that Sarah had kept every email, every draft, every version. In patent court, paper trails have a way of becoming weapons. Sarah Chen was a biomedical engineer with a revolutionary idea, a diagnostic device that could detect early-stage cancers from a single drop of blood. Marcus Webb was the business strategist who promised to bring her vision to market. Together, they formed a partnership built on trust. But when the patent was filed, Marcus made a calculated decision that transformed their collaboration into theft. The question wasn't whether Sarah could prove inventorship. It was whether the legal system would believe her over a man who'd erased her name. The story begins in 2015 at a medical technology conference in Boston. Sarah Chen was presenting her early research on microfluidic diagnostics. She was 32 years old, with a doctorate from MIT and a reputation for solving problems that had stumped the industry for years. Her presentation caught the attention of Marcus Webb, a charismatic entrepreneur who had already built and sold 2 medical device companies. Marcus approached Sarah after her talk with a proposition. He had the business infrastructure, the investor relationships, and the manufacturing connections. What he lacked was a breakthrough technology. Sarah had the breakthrough. What she lacked was the path to market. On paper, it seemed like a perfect match. Over the next 6 months, they met regularly to discuss the partnership. Sarah was cautious by nature. She had heard stories of inventors who lost control of their creations to unscrupulous business partners. Marcus seemed to anticipate her concerns. He offered her a 49% stake in the new company, a seat on the board, and final approval on all major decisions. He even suggested they file a provisional patent together with both their names listed as co-inventors. Sarah reviewed the documents herself. Everything appeared to be in order. Her name was on the provisional patent application filed in November 2015. She was listed as the primary inventor, with Marcus named as a co-inventor for his contributions to the device's commercial applications. The partnership seemed to be built on mutual respect. The company, which they named Nexus Diagnostics, moved quickly. Marcus secured $12 million in Series A funding within 8 months. Sarah led the engineering team, working 16-hour days to refine the prototype. The device, which they called the HemoScan 1, could analyze a single drop of blood for 14 different cancer markers in under 3 minutes. It was faster, cheaper, and more accurate than anything on the market. But there were warning signs that Sarah chose to ignore. Marcus often made decisions without consulting her. He hired executives she had never met. He shifted the company's focus from Sarah's original vision of accessible healthcare for underserved communities to a premium product for private clinics. When Sarah objected, Marcus reminded her of the investors' expectations. The company needed to show profit, and quickly. By late 2018, Nexus Diagnostics was valued at over $200 million. The HemoScan 1 had received FDA approval and was being piloted in hospitals across the country. Sarah appeared in Forbes and was named one of MIT Technology Review's Innovators Under 35. Everything seemed to be going exactly as planned. Then came the meeting that changed everything. In January 2019, Marcus called an emergency board session. He informed Sarah that a major pharmaceutical company was interested in acquiring Nexus Diagnostics. The offer was substantial, $80 million upfront with additional payments tied to future sales. Sarah was stunned. She had not been consulted about a potential sale. She had not even known acquisition discussions were taking place. Marcus assured her that her interests would be protected. As a co-founder and co-inventor, she would receive her fair share of the proceeds. He asked her to sign some routine paperwork to facilitate the deal. Sarah, still processing the sudden news, took the documents home to review. What she found in those pages made her realize that something was terribly wrong. The acquisition agreement listed Marcus Webb as the sole inventor of the HemoScan 1 technology. Sarah's name appeared nowhere in the patent documentation attached to the deal. When she checked the patent database for the full patent filed in 2017, she discovered that her name had been removed entirely. Marcus had filed an amendment to the original application, claiming that Sarah's contributions were purely administrative. According to the new filing, she had never been an inventor at all. Sarah Chen had built the technology that was about to make $80 million, and according to the official record, she didn't exist. Sarah sat alone in her apartment that night, the acquisition documents spread across her kitchen table. She read every page 3 times, hoping she had misunderstood something, but the truth was undeniable. Marcus had rewritten history, and the legal system had accepted his version without question. The next morning, Sarah arrived at the Nexus Diagnostics headquarters before anyone else. She went straight to her office and began searching through her files. She needed proof that she had invented the HemoScan 1, but as she logged into her computer, she discovered that her access had been restricted. She could no longer open the engineering folders, the design specifications, or the research archives. 3 years of her work had been locked away behind a password she didn't have. Marcus appeared in her doorway at 8:15. He was smiling as if nothing had happened. "We need to talk," Sarah said, her voice steady despite the rage building inside her. Marcus stepped inside and closed the door. He sat down in the chair across from her desk, still smiling. "I imagine you have questions about the paperwork. You removed my name from the patents." "I corrected an administrative error," Marcus spoke calmly, as if he were explaining a minor bookkeeping mistake. "The original filing listed you as an inventor, but legal reviewed the contributions and determined that inventorship wasn't appropriate. You were compensated fairly for your work, Sarah. You have your salary, your stock options, your board seat. Nothing has changed." "Nothing has changed. You're about to sell this company for $80 million, and according to the patent, I invented nothing." Marcus leaned forward, his smile faded. "Here's what you need to understand. The investors put $12 million into this company because I built the business. I secured the partnerships. I navigated the regulatory process. You designed a component that's valuable and you've been compensated for it. But the technology platform, the commercial application, that belongs to the company and the company belongs to the shareholders." Sarah stood up. "I'm taking this to a lawyer." Marcus stood as well. He straightened his jacket and walked toward the door. Before he left, he turned back to face her. "You can try, but you should know that the patent was filed almost 2 years ago. The statute of limitations for correcting inventorship is running out, and if you attempt to interfere with the acquisition, the board will be forced to take action against you. I'd hate to see your reputation destroyed over a misunderstanding." The door closed behind him. Sarah stood alone in her office, shaking. That afternoon, she was escorted out of the building by security. The official explanation was a leave of absence for personal reasons. The unofficial reality was that Sarah Chen had become a liability to the people who controlled the company she had built. But Sarah had something Marcus didn't expect. She had a habit that most people would consider obsessive. She saved everything. 2 weeks after losing access to her office, Sarah sat with a patent attorney named Deborah Kravitz in a small conference room in downtown Boston. Deborah had spent 25 years fighting inventorship disputes. She had seen it all: stolen trade secrets, forged documents, betrayed partnerships. But even she was surprised by what Sarah pulled out of her bag. Sarah had brought a laptop that wasn't connected to the company network. On it were copies of every email she had ever sent or received related to the HemoScan 1. She had designed sketches dated and timestamped from 2014, long before she met Marcus. She had lab notebooks with original calculations, signed and witnessed by colleagues at MIT. She had version histories showing every iteration of the device design with her name attached to each change. And she had the original provisional patent application, signed by Marcus himself, listing her as the primary inventor. "I never trusted cloud storage," Sarah explained. "I kept local copies of everything. Every night I backed up my work to an external drive. I figured it was just good engineering practice. I didn't realize I was building evidence." Deborah smiled. "This is good, more than good. We have a strong case for correcting inventorship, but I have to warn you, it won't be easy. Marcus has resources, and he's already taken steps to protect himself. The patent office doesn't just remove someone's name by accident. He filed a declaration claiming you weren't an inventor. That's perjury, but we need to prove it." "How long will this take?" "Months, maybe years, and Marcus will fight every step of the way. He has a financial interest in keeping your name off that patent." Sarah thought about her savings, her career, her reputation. Everything she had worked for was on the line, but walking away meant letting Marcus win. It meant watching someone else take credit for her life's work. Let's do it. The legal battle began in March 2019. Sarah's team filed a petition with the Patent Trial and Appeal Board seeking to correct inventorship on the HemoScan 1 patents. The filing was more than 100 pages long, supported by over 300 exhibits. Sarah's evidence included the original provisional patent, email chains with Marcus acknowledging her role as the inventor, and technical documents that only she could have written. Marcus responded with a team of attorneys from one of the most expensive law firms in Boston. They argued that Sarah's contributions were limited to routine testing and data collection, not actual invention. They claimed that Marcus had conceived the core technology and that Sarah had merely executed his vision. They pointed to her signature on various corporate documents as evidence that she had accepted her non-inventor status. But one piece of evidence caught everyone's attention. In the discovery process, Sarah's legal team found an email from Marcus dated September 2016. It was addressed to the company's patent attorney. In it, Marcus wrote, "Make sure Sarah's name is on the final filing. She's the brains behind this thing, and I don't want any disputes later." The email was sent 9 months before the patent was officially filed. It directly contradicted Marcus's later claims that Sarah was never an inventor. When Sarah saw the email, she felt a surge of hope. It was the smoking gun she needed. But Marcus's attorneys had an explanation ready. They claimed the email was referring to a different filing, a procedural document that had nothing to do with inventorship. They argued that Marcus had been confused about patent terminology and had corrected his mistake before the official filing. The patent office, they insisted, had made the right decision in removing Sarah's name. The case dragged on through the summer. Sarah spent her days reviewing documents and preparing for depositions. Her savings were shrinking rapidly, the legal fees were astronomical, and the stress was affecting every part of her life. Then in August, something unexpected happened. A former employee of Nexus Diagnostics contacted Sarah's legal team. His name was David Okonkwo, and he had worked as a software engineer on the HemoScan 1 project. He had left the company a year earlier, but he had kept copies of internal communications that he thought might be important. What David shared with Sarah's attorneys changed everything. The emails showed that Marcus had been planning to remove Sarah's name for over a year. He had discussed it with his legal team, with investors, and with potential acquirers. The acquisition deal had been negotiated with the explicit understanding that Marcus was the sole inventor. If Sarah's name appeared on the patent, the deal might fall through. More damaging still was a message from Marcus to his lawyer dated October 2017, just weeks before the patent filing. It read, "We need to get Sarah off the inventor list. The acquirers want a clean ownership structure. Can we argue that her contributions don't meet the legal standard for invention? She designed the microfluidic chamber, but the overall concept was mine." Sarah stared at the document. Marcus hadn't just made a mistake, he had deliberately erased her to secure the sale. He had planned it, discussed it with lawyers, and executed it while pretending everything was normal. The question now was whether the legal system would hold him accountable. Sarah's attorneys filed a motion to amend the inventorship, submitting David's evidence as Exhibit A. The Patent Trial and Appeal Board agreed to hear the case. A hearing was scheduled for November. But Marcus wasn't finished fighting. 2 weeks before the hearing, Nexus Diagnostics filed a countersuit against Sarah. They claimed she had stolen company property, violated her employment contract, and damaged the company's reputation. They demanded $3 million in damages and an injunction preventing her from discussing the case publicly. Sarah was now fighting on two fronts, one to reclaim her patent and one to protect herself from ruin. The countersuit was designed to break Sarah. Marcus knew that most people in her position would fold. Faced with a $3 million damages claim and the prospect of years in court, even innocent defendants often chose to walk away. Sarah's attorneys warned her that the legal fees alone could exceed $500,000 before the case was resolved. Her savings would not last forever. But something had shifted in Sarah's thinking. This was no longer just about a patent. It was about the principle that a person's work belongs to them. It was about every woman in STEM who had watched a male colleague take credit for her ideas. It was about a system that allowed powerful people to rewrite history without consequence. Sarah decided that she would rather lose everything than let Marcus win. The weeks leading up to the November hearing were brutal. Sarah barely slept. She spent her nights reviewing documents and her days answering questions from attorneys. Her friends stopped calling because she never had time to talk. Her parents, who lived in California, wanted to fly out and support her, but Sarah told them to stay home. She didn't want them to see her like this. Meanwhile, Marcus launched a media campaign. He gave interviews to technology publications, portraying himself as a visionary entrepreneur who had been betrayed by a disgruntled employee. He described Sarah as a talented technician who had exceeded her authority and attempted to take credit for work she hadn't done. The articles painted Nexus Diagnostics as a success story and Sarah as a cautionary tale about greed. Reporters started calling Sarah for comment. She declined every interview on the advice of her attorneys, but her silence allowed Marcus to control the narrative. Former colleagues distanced themselves. People she had worked with for years suddenly couldn't remember her contributions. The scientific community, which had celebrated her just months earlier, now treated her like a liability. In late October, Sarah received a settlement offer from Marcus's team. She would drop her inventorship claim and sign a non-disclosure agreement. In exchange, Marcus would drop the countersuit and pay her $250,000. It wasn't the millions she was owed, but it would let her walk away with her life intact. Sarah showed the offer to Deborah Kravitz. Deborah studied it carefully. "This is a lowball," she said. "He's worried. If he thought he had an airtight case, he wouldn't be offering you anything. But I have to ask you honestly, can you afford to keep fighting?" Sarah looked at her bank statements. She had enough for maybe 3 more months of litigation. After that, she would have to borrow money or declare bankruptcy. The pressure was agonizing. Then came the discovery that changed the calculus entirely. On October 29th, a paralegal on Sarah's legal team was reviewing documents produced by Nexus Diagnostics during discovery. She found something buried in a folder of financial records, a wire transfer from November 2017. It showed a payment of $200,000 from Nexus Diagnostics to a company called Web Consulting LLC. The payment was labeled Intellectual Property Assessment Services. Sarah had never heard of Web Consulting. She asked her attorneys to investigate. What they found was startling. Web Consulting LLC was registered in Delaware, but its registered agent was the same law firm that had filed Marcus's patent application. The company had no employees, no office, and no website. It existed only on paper, and the $200,000 payment was not the only one. Over the past 2 years, Nexus Diagnostics had paid Web Consulting over $1.4 million for various consulting services. The money trail led to an uncomfortable conclusion. Marcus was siphoning money from the company into a shell entity he controlled, and the timing was suspicious. The largest payment, $400,000, had been made just 3 days before the patent amendment that removed Sarah's name. But the real bombshell came when Sarah's team subpoenaed Web Consulting's bank records. The account showed outgoing payments to 2 individuals, an administrative law judge named Richard Hollowell and a patent examiner named Susan Chen, no relation to Sarah. The payments totaled $60,000 over 18 months. Sarah stared at the documents in disbelief. Marcus hadn't just lied to the patent office, he had paid off the people responsible for reviewing his claims. The implications were staggering. If Sarah could prove that Marcus had bribed a patent examiner and an administrative judge, the entire patent would be invalidated. Not only would her inventorship claim succeed, but Marcus could face criminal charges for fraud and corruption. The $80 million acquisition would collapse. Nexus Diagnostics would be destroyed. But proving bribery was extraordinarily difficult. The payments were disguised as consulting fees. There was no direct evidence that Hollowell or Susan Chen had done anything improper in exchange for the money. They could claim they had provided legitimate services even if no such services existed. Sarah's attorneys debated their next move. They could report the findings to federal prosecutors, but that would mean handing over their evidence and waiting for a criminal investigation that might take years. They could present the evidence in the civil hearing, but that would tip their hand and give Marcus time to destroy additional records. Or they could continue building their case quietly, gathering more evidence before making any accusations. They chose the third option. In the days before the November hearing, Sarah's team worked around the clock. They interviewed former employees, analyzed financial records, and traced every connection between Marcus and the people he had paid. They discovered that Richard Hollowell had retired from the administrative law judge position in June 2018, just months after the patent amendment was approved. His retirement had been sudden and unexpected. Susan Chen had been transferred to a different department around the same time. More importantly, they found emails between Marcus and his patent attorney discussing Hollowell by name. In one message, Marcus wrote, "Hollowell understands the situation. He'll make sure the amendment goes through smoothly." The attorney had responded, "Make sure the payment goes through the consulting arrangement. We need clean hands." It was not a confession of bribery, but it was evidence that Marcus had expected Hollowell to influence the patent process in exchange for payment. The hearing on November 15th was held in a federal building in Alexandria, Virginia. Sarah sat at a table with her attorneys, facing Marcus and his legal team across the room. 3 administrative judges from the Patent Trial and Appeal Board presided from a raised bench. The room was silent as the first witness was called. Marcus's attorneys had prepared a meticulous defense. They argued that Sarah's name had been removed from the patent because her contributions did not meet the legal standard for inventorship. They presented technical analyses claiming that the microfluidic chamber was an obvious extension of existing technology. They pointed to Sarah's signature on corporate documents acknowledging her role as an employee, not an inventor. But when Sarah's attorneys presented their evidence, the mood in the room shifted. They started with the original provisional patent listing Sarah as the primary inventor. They showed Marcus's email acknowledging her as the inventor. They introduced David Okonkwo's testimony about Marcus's plan to remove her name. Each piece of evidence built on the last, creating a picture of deliberate deception. Then came the financial documents. Sarah's lead attorney placed the wire transfer records on the display screen. She walked the judges through the payments from Nexus Diagnostics to Web Consulting. She showed the subsequent transfers to Richard Hollowell and Susan Chen, and she read Marcus's email about Hollowell making sure the amendment went through. The judges asked to see the documents more closely. They conferred among themselves. Then one of them turned to Marcus's attorney and asked a question that made the entire room go still. "Can you explain why your client made payments to a sitting administrative law judge through a shell company?" Marcus's attorney hesitated. He looked at Marcus, then back at the judges. He promised to provide an explanation after reviewing the documents more thoroughly. The hearing was adjourned for 2 weeks. Sarah walked out of the building feeling something she hadn't felt in months: hope. But the victory was short-lived. 3 days after the hearing, Sarah received a call from Deborah Kravitz. Her voice was tense. "Sarah, you need to sit down. Something has happened." Federal agents had raided Nexus Diagnostics headquarters that morning. They had seized computers, files, and financial records. The Department of Justice had opened a criminal investigation into the company's patent filings. On the surface, this seemed like good news. The evidence of fraud and bribery was being taken seriously. But the investigation also meant that the civil case would be put on hold indefinitely. The acquisition was dead, Nexus Diagnostics was in crisis, and Marcus, facing potential criminal charges, had disappeared. Sarah felt no satisfaction. She had wanted justice, but she had also wanted recognition. She had wanted her name restored on the patent that represented her life's work. Now the patent itself might be invalidated entirely, caught in the wreckage of Marcus's crimes. She might win the battle and lose everything she had fought for. That evening, Sarah received an anonymous email. The sender's address was encrypted, and the message contained only one sentence: "You don't know the half of what he's done." Attached to the email was a file containing hundreds of documents. Sarah opened it and began to read. What she found would change everything she thought she knew about Marcus Webb, Nexus Diagnostics, and the true scope of the conspiracy against her. Sarah spent the entire night reviewing the documents, her mind racing as each new file revealed another layer of the conspiracy. The anonymous source had provided something beyond anything her legal team had uncovered: internal communications from Marcus's personal email account, financial records from offshore accounts, and a spreadsheet tracking payments to over a dozen people involved in the patent approval process. The scope of the fraud was breathtaking. Marcus hadn't just bribed one judge and one examiner. He had systematically compromised the entire patent review process over 3 years. The payments totaled more than $2.3 million, funneled through 6 different shell companies registered in Delaware, the Cayman Islands, and Cyprus. Each payment was coded as consulting fees, legal services, or research support. But the most damning evidence was a document titled Inventorship Strategy, dated September 2017. It was a memo Marcus had written to himself, outlining his plan to remove Sarah from the patent. The memo listed her contributions in detail: the microfluidic chamber design, the blood sample preparation protocol, the sensor calibration algorithm. Every element that made the HemoScan 1 revolutionary was acknowledged as Sarah's invention. Then, in cold analytical language, Marcus outlined how to argue that none of these contributions met the legal standard for inventorship. The final paragraph was devastating. It read, "The key is framing her work as implementation rather than conception. The patent bar for inventorship is deliberately vague. If we control the narrative and the paperwork, we control the outcome. Sarah trusts me. By the time she realizes what happened, it will be too late." Sarah forwarded the entire file to Deborah Kravitz at 3:47 in the morning. Deborah called her back within minutes, despite the hour. "This changes everything," Deborah said. "With this evidence, we can go directly to the federal prosecutors. This isn't just a civil matter anymore. This is criminal fraud on a massive scale." 3 days later, Sarah sat in a conference room at the Department of Justice with 2 federal prosecutors and an FBI agent. They had been building their own case against Marcus based on the raid on Nexus Diagnostics, but the documents Sarah provided gave them everything they needed. The evidence trail was now so complete that there was no room for Marcus to maneuver. But Marcus Webb had vanished. He had not been seen since the day of the federal raid. His attorneys claimed they did not know his location. His wife had filed for divorce and refused to comment. The company he had built was in freefall, with investors fleeing and employees resigning en masse. The $80 million acquisition was dead, killed by the scandal. For Sarah, the situation was bittersweet. She had the evidence to prove everything. But the patent that represented her life's work was now tainted by fraud. Even if her inventorship was restored, the HemoScan 1 might never reach the patients who needed it. The technology she had created to save lives was now a footnote in a criminal case. Then, in December, came a breakthrough that no one expected. Federal agents tracked Marcus to a luxury apartment in Singapore. He had transferred millions of dollars to offshore accounts before disappearing and was attempting to establish residency in a country with no extradition treaty to the United States. But he had made a mistake. One of his shell companies had maintained a bank account in New York, giving prosecutors jurisdiction. After 3 weeks of diplomatic negotiations, Singaporean authorities agreed to detain Marcus pending extradition proceedings. On January 8, 2020, Marcus Webb was escorted off a plane at JFK Airport in handcuffs. Cameras captured the image of the once celebrated entrepreneur, head down, flanked by federal agents. The photograph appeared on the front page of the New York Times the next morning. Sarah watched the news coverage alone in her apartment. She felt no triumph, only exhaustion. The past year had cost her nearly everything: her savings, her career, her peace of mind. But she had something now that Marcus could never take away: the truth. The criminal case proceeded quickly. Faced with overwhelming evidence, Marcus's attorneys negotiated a plea agreement. In March 2020, Marcus Webb pleaded guilty to 8 counts of wire fraud, 2 counts of bribery, and 1 count of perjury. He was sentenced to 7 years in federal prison and ordered to pay $4.6 million in restitution. He would never work in the medical device industry again. But the most important outcome for Sarah was the patent ruling. In April 2020, the Patent Trial and Appeal Board issued its decision. Sarah Chen was formally recognized as the sole inventor of the HemoScan 1 technology. Marcus Webb's name was removed from all patent documents. The official record had been corrected. Sarah stood outside the patent office building in Alexandria after receiving the news. She held the corrected patent certificate in her hands, staring at her own name printed at the top of the document. 3 years of fighting, 3 years of being told she didn't deserve credit for her own work, 3 years of doubt, fear, and isolation. It was finally over. But there was one final surprise still to come. 2 weeks after the patent ruling, Sarah received a call from the Department of Justice. The prosecutors had finished their asset forfeiture proceedings against Marcus. Among the seized assets was his ownership stake in Nexus Diagnostics. Because the company's primary asset was the HemoScan 1 patent, and because Sarah was now recognized as the sole inventor, the government had made a decision. They were offering Sarah the patent rights to her own technology. It wasn't a gift. She would have to negotiate with the bankruptcy court and assume certain liabilities from the collapsed company. But for the first time, Sarah Chen would own her invention outright. No partners, no shareholders, no one who could claim credit for what she had created. In September 2020, Sarah founded a new company called Chen Diagnostics. She acquired the HemoScan 1 patent for $200,000, a fraction of its true value. With the help of angel investors who had followed her story, she began the process of bringing the technology to market on her own terms. Today, the HemoScan 1 is used in hospitals and clinics across 12 countries. It has screened over 2 million patients for early-stage cancers, catching diseases that might otherwise have gone undetected until it was too late. Sarah Chen's name appears on every device, every patent, every scientific paper. The credit she fought for is now undeniable. But the story doesn't end with victory. During the legal proceedings, investigators discovered that Marcus had done this before. In his first company, a medical imaging startup sold in 2012, a female engineer had been erased from the patent. She had settled quietly and signed a non-disclosure agreement. In his second company, a diagnostic software firm, 3 different contributors had been removed from patent filings. Each time, Marcus had taken credit for work he hadn't done. Each time, his victims had lacked the resources or the will to fight back. Sarah was the first to refuse to stay silent. Her case set a precedent in patent law. Courts now scrutinize inventorship amendments more carefully, particularly when they involve removing names from existing patents. The legal standards for proving inventorship have been clarified, making it harder for unscrupulous partners to steal credit. And the Department of Justice has established a dedicated unit for investigating fraud in the patent system. Sarah Chen lost nearly everything fighting for recognition, but in the process, she changed the system that tried to erase her. The woman who saved every email, every draft, every version had preserved more than her own reputation. She had preserved the principle that invention belongs to the inventor, no matter how powerful the forces aligned against them. Sarah Chen's story is not unique. Every year, inventors across the country discover that their names have been removed from patents they helped create. Most of them never fight back. The cost is too high, the odds too long, the system too tilted in favor of those with money and power. Sarah had something most people don't, a habit of saving every document, every email, every version. But even with that evidence, she nearly lost everything. The patent system was designed to protect inventors, to ensure that people who create new technologies receive credit and compensation for their work. But like any system, it can be manipulated by those who understand its weaknesses. Marcus Webb exploited those weaknesses for years. He wasn't a genius. He was simply willing to do things that honest people won't do, and for a long time that was enough. What stopped him was a woman who refused to accept a lie. In the end, this story isn't really about patents or lawsuits or corporate fraud. It's about the fundamental human need to be recognized for our contributions. It's about what happens when that recognition is stolen and what it costs to get it back. Sarah Chen spent 3 years and nearly $500,000 to have her name printed on a document that should have borne it from the start. The system is changing slowly because of cases like hers, but there are still countless inventors whose names we will never know, whose creations made other people wealthy while they were left behind. The question isn't whether fraud happens. The question is how many Sarah Chens are out there, right now, fighting battles no one will ever hear about. If you found this story compelling, please consider subscribing to the channel for more documentaries like this one. Your support allows us to keep telling the stories that need to be told.